Here's the script, 943 words. There is a mechanism called the Congressional Accountability Act Settlement Fund. It appears in no law you've ever read, and it has a proof point that should stop you cold. Since 1995, it has paid out taxpayer money to cover claims against members of Congress, and the law does not require the public to ever learn which member's conduct triggered the payment. Here is what it actually is, in plain terms. When a member of Congress or a congressional office is accused of harassment, discrimination, or retaliation, the claim doesn't go to a normal court the way a lawsuit against your own employer would. It moves through a private internal process, and if it settles, the money comes from neither the member's pocket nor their office budget. It comes from a permanent, indefinite account at the United States Treasury, funding that never needs reapproval, never appears as a specific expense anyone has to explain, and exists to make these claims disappear quietly, on the government's dime. No one voted on this the way you'd expect. It was built into the Congressional Accountability Act of 1995, a law sold to the public as a reform, a promise that Congress would finally hold itself to the same workplace laws as everyone else. Buried inside that reform was the mechanism that undid its own promise, a confidential process run by an internal office that could resolve claims through mediation and settlement before they ever became public. For 22 years, almost no one outside that building knew the fund existed. It surfaced in 2017 during a wave of public reporting, when investigators found the Treasury had quietly paid out more than $15 million in settlements tied to congressional workplaces since the fund's creation. And in nearly every case, the member's name, the office, and the underlying conduct stayed sealed. Congress did respond, eventually, under public pressure. In 2018, lawmakers passed a reform requiring members to personally reimburse the Treasury for settlements tied to their own harassment or retaliation. That sounds like accountability, but the requirement only applies once a case reaches a specific legal finding, and most never do, because they're resolved through confidential mediation first. The people who actually control the fund now are the same offices that administer the settlements: the Office of Congressional Workplace Rights and the employing offices themselves, deciding internally what gets disclosed and what doesn't. Here is the part that should actually change how you see this. If you worked for a private company and filed a harassment claim, the settlement would still, in most cases, leave some kind of trace: a court filing, a regulatory record, something a determined person could eventually find. If you work for a member of Congress, the claim can move through this fund, get resolved, get paid by the Treasury, and leave almost nothing behind that a citizen can retrieve. You cannot look up which offices have paid claims through it in any given year. You cannot cross-reference a specific member against a specific payment unless Congress itself chooses to release that detail, which it rarely does. Say you are a young staffer on Capitol Hill right now, working for a member whose name you'd recognize instantly. If something happens to you in that office, the process that resolves it was not designed to protect you. It was designed to protect the institution from the appearance of scandal, while still technically complying with a law Congress wrote about itself. The $15 million already paid out is not speculation. It is documented. What is not documented is nearly everything underneath it: who, why, and how many times it has happened since. And here's the part that should actually worry you: it's completely legal. This isn't a loophole anyone is quietly exploiting against the rules. It is the rule. Repealing it would require the very body it protects to vote to expose its own settlement history retroactively, which means asking sitting members to authorize the release of records that could implicate colleagues, donors, and committee chairs they depend on for their own survival in that building. No outside court can force it, because Congress wrote the confidentiality into its own internal compliance process, and courts have historically deferred to Congress's authority to govern its own internal workplace disputes. The fund is structurally self-protecting. It was not hidden by accident. It was built so that the only people with the power to expose it are the same people it was built to shield. This is the part that should bother you about more than just this one fund. If a law explicitly sold to the public as an accountability reform can contain a permanent, self-concealing exception inside it, the question stops being about Congress's workplace claims specifically. It becomes about every other reform you've been told exists. Financial disclosure requirements, ethics review boards, inspector general offices. Each one exists because someone insisted it should, and each one can be quietly narrowed by the same people it is meant to constrain, using a mechanism nobody outside the building ever reads closely enough to notice. The settlement fund isn't unusual because it's uniquely corrupt. It's unusual because it got caught. Most mechanisms like it never do. And remember, no one voted on any of this. So the number that matters isn't $15 million. It's the number of funds like this one that haven't had their 2017 moment yet. The ones still operating quietly, inside institutions that write their own rules of disclosure, waiting for a reporter, a whistleblower, or an accident to bring them into view.